If you are getting divorced, then either you or your spouse is a beneficiary under a trust which will provide you with capital or income. This may be regarded as a financial resource. There's a possibility it will be considered by the court as part of the financial remedy proceedings of the divorce. However, it's not cut and dried, as each situation will be unique. Director Lucy Theobald is here to give us information on how trusts are considered in divorce. So, Lucy, if someone has assets in trust, is it always the case that the court will split this between the couple during the divorce?
This will largely depend on whether or not the settlement is a nuptial or non-nuptial settlement. If the settlement is nuptial, then the court can look into whether or not those assets should be divided, but this will be done in a specific and discretionary way. If the settlement is non-nuptial, then the court cannot interfere with that trust, and the court can, though, make direction for those specific assets to be used in a way that would assist the matrimonial settlement.
And can assets be protected from division during divorce by putting them in a trust during the marriage?
If you move assets during the course of the marriage and you put those into a trust, then the court are likely to view those as a nuptial settlement, and therefore they can be used as part of any divorce settlement between the parties. The best way to protect any assets generally is to use what's likely to be a post-nuptial agreement, but you would need advice as to how to go about that and the consequences of moving those assets.
Great, thank you. And what happens to intergenerational trusts?
Intergenerational trusts are normally set up by families to benefit the younger generation, and now they're really to exist for a longer period of time. Generally, they're for education funds, or for nowadays, if children want a deposit for their first property, then they would be used for that. They're generally regarded by the court as non-matrimonial property, and therefore if the court don't have to have recourse to that trust, then they won't. But again, the overriding interest generally is that if the needs of the parties trump that trust, then those assets will be used.
And how does the family court approach trust assets?
The court can make various orders varying the trust, or they can make judicious encouragement orders which would help try and use those assets in the best way possible to benefit both parties and any children of the family. The court can remove trustees if they want to, and they can, if necessary, give more of the non-matrimonial assets to a party to compensate them, as they will not be receiving any monies from the trust.
And finally, how is it best to approach divorce where trusts are involved?
As you can probably see from this morning, trusts are actually quite complicated, and therefore it's much better to have a solicitor who's used to dealing with trusts and divorces. And we would always recommend a financial planner to assist you with that as well, so that you can meet your needs now and, of course, those needs in the future.
Lucy, thank you very much.
Thank you.
As Lucy has explained, divorces where trusts are involved are not straightforward. Each situation will be unique, and so having an experienced team of experts could be crucial to the outcome.